Any mention?
Your Lordships, I beg to make a mention of item number 1.
Once admission, you can't mention on hearing matters. Yes.
Item number 1.
Call out the file. Yes.
Your Lordships, the conducting counsel is S.K. Hassan. I'm only appearing under instructions.
What happened to him?
He is unable to appear due to personal difficulties, Your
Have you
Lordship.
taken steps for serve notice on respondents?
No, Your Lordship, due to time constraints, they could not take steps
What
upon
is your
the
name?
remaining respondents. S. Kharpran, Your Lordship.
MSS Harpan submits that due to constraints of time, steps could not be taken on the flight respondents.
Lordship, yes.
She prays was allowed 1 week's time to take steps list after 2 weeks. Yes.
Oblige,
Your
Lord.
Lordship.
Hearing item number 2.
Yes.
Wait, please, Your Lordship.
Ready the matter today?
My friend is also here. So let's start, man.
Yes.
This is a writ appeal, Milan, arising out of the order dated 1/4/2024. 2024. That is the impugned judgment in the writ petition. Here, Milan, the case in brief is that the appellant's father he was an employee of the bank, Milan, Vijaya Bank, and then he expired in harness while on service.
He was working as?
He was a guard, I think, bank guard. And then after he expired in harness, Milan, there was his wife, that means the mother of the petitioner, made an application for compassionate appointment. And subsequently, Milan, she was informed that compassionate appointment has been done away with, and in lieu of that, they were giving some amount of money, Milan. So she duly applied for that. And then that was initially denied to her.
Health rickshaw payment.
That ex gratia payment in lieu of thing, Milan. And then she came for the first round of litigation, Milan. And in that first round of litigation, Milan, the order denying.
Where is that order?
That was
Page?
Milan.
It's 110.
110.
Which page wrong? Yes.
Well, the crux of the case here is the calculation of the amount. That is the crux, Milan. So, if your Lordship comes to page 111, Milan,
Yes.
111, we can go straight to para 7, Milan.
Yes.
7. A reading of clause 5 shows that the family includes only dependent children, and therefore it may not be appropriate in my view to take into account the income of a non-dependent child. So that non-dependent child's income was included in calculating the limit, the limit for the, because
The eligibility.
eligibility. So that was included, and so by this honorable the judgment of this honorable court, my lord, it was held that the income of the non-dependent child may not be taken into account to compute the family's income for the purpose of considering eligibility for ex gratia relief under the bank scheme notified on 4/10/2004. But since rupees 3,000 earned by the non-dependent son Vidyut Das is included to compute the family's monthly income to reach a figure of rupees 6,647.50, which is more than 60% of the last drawn salary of the deceased employee, I feel that recalculation of the family income of the petitioner by excluding
What
the...
happened after this?
So, that was satisfied, and it was directed that his income is to be excluded. Now, again, she made application and all that.
Yes.
And, there was this second time also, it was denied. Now, if your lordship comes to page 120, that is a letter of denial, my lord. I'll take your lordship to page 121. Accordingly, this is the reply given, my lord. Accordingly, your monthly income was arrived as under. Now, amounts received by way of terminal benefits,
Yes.
Provident Fund rupees 65,000 so and so, gratuity so and so, total so and so, rupees 1,31,788. Now, monthly income of the family by way of interest on net corpus terminal benefits is rupees 906. Now, family pension from the bank, this is rupees 3,088, and family pension from defense, that is rupees 2,377. So, totally monthly income from all sources, rupees 6,371. 60% of the last drawn salary of late Rajendra Kumar Chandra Das is rupees 3,997. In the above circumstances, it is observed that the family income of the dependents from all sources, excluding the income of Sri Vidyut Das, is more than 60% of the last drawn salary of the deceased employee. Hence, you are not eligible for ex gratia as per the provisions contained in the revised scheme for payment of ex gratia payment in lieu of appointment on compassionate ground. So it was denied, my lord.
Yes.
Now, my lord, this we have assailed before your lordship now.
Yes.
We have assailed, my lord, on the ground that the family income was to be calculated as on the date of the demise.
Date of demise.
Date of demise, my lord. My lord, the common sense, my lord. And that the correspondences also say that, my lord. As on the date of demise, my lord, this family pension from bank and family pension from defense, these were not the income of the family. These were not there, my lord. As on the date of demise, these came subsequently. So, as on the date of demise, if the family pension is to be calculated, my lord, then these cannot be included.
How do you validate your submission? Because family pension will come only after death, and then at the date of demise they'll have zero income.
Yes, my lord. On the date of demise, my lord, their income, there is no income. That is my humble thought.
How do you validate your submission?
My
On
lord.
what basis to show that for calculation of
My lord, I'll
of
take
the
your lordship.
family income that it has been the date of demise?
My lord, if it is not on the date of demise, now suppose now on the date of demise or that she is found eligible, and then subsequently some income comes in, my lord, then will the ex gratia payment which has been given, my lord, that will not be withdrawn.
See, because if you look at the the entire idea behind compassionate appointment is that to to help them overcome the financial difficulties
But-
they have when the breadwinner dies. Now the thing is that if your family pension and the other pension, it doesn't allow.
Well, I'll take your lordship
You kindly show that, yes.
to the correspondence also, my lord.
Shorten
The correspondence also says that, my lord. I'll take your lordship, my lord.
Can you see the scheme?
Yes, yes,
Yes,
yes.
yes.
Yes, yes.
That scheme is the.
The scheme is also
source
there.
of your, claim.
Scheme is also there.
Just examine the scheme.
Madam. 154.
154.
154.
It starts at page 146.
I'll take a lodge through the scheme mill. Your lordship is at page 146, ma'am?
Yes.
Revised scheme for payment of ex gratia amount in lieu of appointments on compassionate grounds and appointment of dependents, deceased employees on compassionate grounds. In supersession of earlier circulars, number so and so dated 2004, Government of India issued revised guidelines as communicated by Indian Banks Association with a letter number so and so dated 19/7/2007 with regard to appointment of on compassionate grounds of dependents of deceased employees and payment of ex gratia amount in lieu of appointment on compassionate grounds. Accordingly, the Board of Directors have approved the revised scheme. Now, the background is given. Well, I think your lordship can come straight to page 150.
I am there.
It is the principles laid down by the Supreme Court in its judgment in Sri U.K. Nagpal versus State of Haryana and others that the object of any scheme for appointment on compassionate grounds is not to give a member of the deceased employee's family a post, much less a post for a post held by the deceased, but to provide relief to the family of the deceased employee to tide over the sudden crisis brought about by her premature death. The relief envisaged could be of a nature which would provide the distressed family immediate succor and financial assistance to recover from the unexpected deprivation of the income of the sole breadwinner of the family. Keeping this in perspective and with a view to bring about a balance between the business objectives of the banks and their social obligations towards the family of the employees dying in harness, a scheme is being proposed for grant of ex gratia amount to the family of the deceased employee in lieu of appointment on compassionate grounds with certain exceptions as provided under para 1.2 chapter 1. Details of the revised schemes are furnished hereunder under chapter 1 to 4. Applicability of the scheme has been furnished under chapter 1. Scheme for payment of ex gratia payment amount in lieu of appointment on compassionate ground of the deceased employees furnished under chapter 2. Scheme for payment of ex gratia amount. This is the objective which has been laid down, Millard, and thereafter the scheme, Millard, at page 152. Millard, page 154, Millard, the eligibility criteria. Dependents whose monthly income from all sources is less than 60% of the last drawn gross salary of the employee are eligible to receive ex gratia amount under the scheme. The monthly income of the dependent shall be calculated as under terminal benefits, provident fund, gratuity, leave encashment, any other amount paid under bank schemes subtotal. So these are the heads which have been laid down. Then liabilities, loans taken from the bank and or other financial institutions with the prior approval of the bank. Now, net corpus terminal benefits, investments, deposits, NSCs, PPF, LIC policy, others. Details of movable property, if any, held and monthly income derived therefrom. Details of immovable property, if any, held. Monthly income of the family from all sources. Monthly interest at the bank's maximum term deposit rate. Monthly income from investments. Monthly income from movable and immovable property. Monthly income of dependent from family members. Any other monthly income. So these are the things. So pension is not included here. If a person gets some pension subsequent to the death, that is not included here. Now,
in your case is that it should not be included. The calculation should be on the,
as on the date of death. Now, by
these heads.
Under these heads, these are specifically laid down here, Millard. And Millard, the correspondence which came from the bank, Millard, that is 8/2/2013. Letter. Page. What? 81. Yes, 81. No, before that. If your lordship comes to page 116, that is 116. 116.
After we just go to the single bench's judgment, we see what here raised the contentions before the.
Only this correspondence. Page 116, Millard. 116. This is the correspondence from the bank, Millard, are asking her to submit her application. This has reference to the court order dated 3/8/2012, that is the earlier order, Millard. As per the court order of the court order, the monthly family income of the dependents has to be recalculated. Hence, you are requested to provide the following details as on 9/12/2000. They are also saying, Millard, as on 9/12/2001 is the date of demise.
But they have indicated family pension and.
If there is any pension.
But on that date, he was working for guard, correct? He was already drawing one pension from the defense, correct?
The
deceased employee.
Deceased employee.
He was working. He had two jobs, right? From what we can gather, is that he was working in the defense before, correct? He's drawing a pension from there. And then with this indicated here, family pension drawn from defense by the dependents. Yes.
Loan outstanding. But here, Millard, they are also including the family pension which he has
yet to receive, you mean?
Which she was not receiving as on that date. So and this family pension drawn from defense, Millard, that also there is a certificate from the state bank, Millard, where the pension was being deposited. As on 9/12, Millard, whatever is the income of the wife, Millard, that has been indicated in the bank's certificate. I'll just take your lordship to that, Millard.
All these facts have been pleaded before the single judge.
My lord, it was pleaded. It was pleaded.
Yes.
Millard, I'll take your lordship to the bank's certificate.
Yes.
Where's the bank certificate?
You have the authority to show that in other cases where similarly such situations have happened, where the calculation of the income is on the demise. Do you have any?
As of now, I don't have it. As of now.
The banks must be having this situation. It's not a question. It's not a peculiar kind of case. Must be having situations. Yes, Mr. Yuva.
But if I've given a minute, today actually I was not all that prepared. I was not that fluent in my.
You just come with authority. You have any?
Whatever.
You just examine the order of the
judgment.
The findings. Yes. Yes.
Lordship, sorry, Lordship, I thought learned senior counsel has completed.
No. He's just saying that he's not really prepared today. But with the yes, we can give you some more time. There's no issue. But the thing is that you'll have a fixed date. Please count authorities. If you because the thing is that the single bench judgment.
Single bench judgment says, I'll take your Lordship to the observation on this point. This point.
Look, this issue is very short. Only whether income all sources, as calculated by them, exceeded 60% of the last period.
That is the
only issue.
That is the
question. Correct. That's only
that is the only issue.
Yes. Just show us the relevant paragraphs. We'll fix another day. You can come prepared. But just so that you have a little heads up. Yes.
My lord.
Yes.
If you come, Lordship Counsel, page 170, Milord.
Yes.
My lord, if your Lordship comes to page 70, Milord, para 23, Milord. The contention of the Senior Counsel for the pension, for the petitioner, that as on the date when the deceased employee died, the total income of the original petitioner was below 60% mark, as she has not received any monthly pension from the bank due to her deceased husband, cannot be accepted, as it is evident that since the deceased employee died in harness on his death, his family, or rather the original petitioner, would be entitled to such monthly family pension, even if the same is given at a later date. She would still be entitled to arrears thereof. Now, Milord, this is not a presumption, but this is an observation of the Honorable Senior.
This observation.
This is not borne out by the facts. From the certificates given by the bank where the person was having the account and owner, that is not. So,
yes, you have any judgments? Similar case?
Similar, Lordship. Firstly, the employee died in 2001. It's though at that time the scheme was not there, bank offered her in 2011.
But before that, compassionate scheme must have been there.
Lordship, before that instruction I have to take, but at the time of his death there was nothing. So this scheme came in 2007.
No, this scheme not nothing. This scheme may not have been there at that point of time. But there must have been some other scheme, relevant scheme at when the date of his demise. He died in 2001.
2001. Now that instruction I will take whether the only thing
whether you can apply the scheme retrospectively. This scheme,
because she was in a financial difficulties, we offered her that though your husband died in 2001, we are giving you this benefit to avail this scheme. But Lordship, now she has died. The Bidut Das has filed an appeal. Now in the first round,
Bidut was a dependent till now.
No.
And in the
He is just continuing his mother's case.
The whole concept of compassionate ground gets diluted.
Yeah.
I mean, it gets washed away. But compassionate ground was used to address the immediate financial,
But the entitlement.
crisis that anybody feels
Lordship,
and faces.
Lordship, what I wanted to submit.
I'll satisfy your lordship on this.
In the first round, the same Bidut Das projected himself as a non-dependent, and due to that projection only the order was passed. Lordship would kindly see at page 111.
We've seen that order, yes. So
Yes.
that order, at that point of time, it ordered that non-dependence income should not be factored in, calculated together with the income of the family. Correct?
Yes, Lordship. But while calculating the claim of Bidut Das, now we have to see whether he is dependent or not.
No,
Now
whether you can still sustain. Has he acquired a vested right in the sense that
it is not a heritable right. That is also my point. Therefore,
come prepare the next date. You bring authorities also, because you see the one thing that strikes our mind is that he died in 2001. This scheme was not. Now you're seeking to give the benefit of the 2007 scheme, correct?
yes, Lordship.
Anyway,
But Bidut Das is not eligible for.
that you argue. You just come prepared. We'll dispose next date.
Well, first week of March.
March. Yes.
We might be a little.
Yes.
Lordship, keep it as part heart. Lordship, please.
Why are you so apprehensive?
No, Lordship, hearing has taken place. Therefore,
In fact, this is the only bench which can take it up. The other division bench cannot take it up because.
no, that is one thing. The hearing took place. Therefore, I am praying.
No, the
But I
other
can
judge
remain
can
part.
hear.
I have no problem. Remain.
Yes, heard in part, yes, for further hearing on first week of March. Yes.
Deeply.
Obliged.
Deeply obliged.
Any mention?
Please, Your Lordship. Your Lordship, I'd like to mention item number 27. If Your Lordship can have this matter after 2 weeks.
Why?
This is regarding that special advertisement, Your Lordship, in Sericulture Department.
Page 7?
27.
Yes.
No objection, Your Lordship.
Yes.
Similar prayer for item number 34, Your Lordship.
34.
Yes, Your Lordship.
Who's other side?
Yes, Your Lordship. No objection, Your Lordship.
Yes.
Right, Your Lordship.
May it please Your Lordship. Your Lordship, I beg to mention item number 28, Your Lordship. Your Lordship, in this matter, Mr. Adaya Moment was there, Your Lordship, but it has been re-endorsed to the senior government
He's
advocate.
been ill for quite some time now.
Yes, Your Lordship,
Then?
it's been re-endorsed to the
Where do you
senior
matter
government
today?
advocate.
Different form, Your Lordship, so have it on the next date, Your Lordship.
Okay, 2 weeks. Yes.
Much obliged, Lordship.
Yes.
Lordship, I beg to mention item number 32 of the main list, Lordship.
30?
31, Lordship. Lordship,
Main list only is going.
Lordship, here, Lordship, what has happened is Lordship has directed for survey in the matter. Lordship, we are yet to obtain instructions with regards to that.
Lordship, no objection.
Now what happened?
Lordship,
Is there that
we
pillar,
will
that
have
picture
Lordship,
that you have
pillar number
given
11, Lordship.
Then what
So
happened?
we are yet to ascertain whether survey,
Certain what?
whether survey has been done at all, Lordship.
Where's Dr. Mozika?
He's on next, Lordship.
Has survey been done?
Lordship, we have no instructions from department, Lordship.
Okay. Yes.
Lordship, similar prayer for item number 32. Lordship, here Mr. Thapa is leading in this matter. Lordship, he's bedridden, Lordship. So I'm
He's?
praying. He has some health issues, Lordship. So I'm praying, Lordship.
Okay, 2 weeks. Yes.
Hello, Lordship.
May please, Your Lordship. I beg to mention item number 33, Lordship. I'm for respondent number 9 in this case.
Where's the petitioner? P.T. Sangma. He's not here.
He's not here, Lordship.
You've taken consent.
No, Your Lordship. I didn't find him here only.
You didn't
I'm
find a meaning?
I didn't.
What's the matter about?
Your Lordship, the petitioner here intends to transfer the domestic violence case registered against the petitioner in.
No,
East
we'll
Kas-
have it next week.
Yes, Your Lordship. Deeply obliged.
1 week, yes.
Please, Your Lordship. Lordship, I beg to mention item number 24. Lordship, I pray that this matter comes on Monday.
Who's other side? On Monday? If you adjourn, you can't take your date. Who's leading you the case?
Sri SD, Your Lordship.
SDEB?
SD, Your Lordship.
Who's SD?
Sujit Days.
Okay. After 1 week. Yes.
Highly pledged.
The part hurt matter actually. Anyway,
It was heard, Lordship. It was heard, Lordship.
it's ready for judgment.
Lordship. Probably, Lordship.
What is the matter about?
Lordship, the matter is about the rejection of the application for grant of NOC or study leave.
Not study leave.
Study leave, Lordship.
Okay, yes.
Please, Lordship, I beg to mention item 25.
Yes. You for the petitioner?
Yes, Your Lordship.
But it was P.T. Sangma's petitioner.
Oh. My apologies, Lordship. I'm for respondent
you-
number 7.
Okay, after 1 week, yes.
Obliged, Lordship.
Supplementary list item number 1.
May it please Your Lordship.
Yes.
I'm praying if Your Lordship would take this matter at the end of the board.
What's the matter about?
Lordship,
I have an interim praise.
Lordship, yes.
What's the matter about?
This is regarding the retirement age of the casual employees, which was reduced to 58, Lordship. We had mentioned it yesterday.
Okay, yes.
Lordship, at the end of the board, the senior counsel is on next. At the end of the board, senior counsel is on next.
2.
Similar prayer, Lordship.
Same.
Same. 3 and 4 as well, Lordship, because senior is leading the matter. 3 and 4 is regarding the city.
So we finish the supplementary list. Yes,
Lordship.
Daily list item number 1.
Please, Your Lordship.
Yes. Who's Where the other side?
Paul Pasque was appearing, my lord, last occasion.
With post for admission hearing?
Yes, my lord.
Yes, of admission, not admission hearing.
Lordship.
Yes, heard Mr. A.G. Moment, learned counsel for the appellant. None appears on behalf of the respondent. Stop the condemnation. This appeal has been listed today for admission.
Yes.
As respondent not present, this after 1 week.
Lordship.
Admission is.
Hello, my lord.
2.
May it please, Lordship.
Yes.
Lordship, I prefer an appeal against the impeding order dated 22/10/2024. Lordship, here in the respondents actually have entered appearance.
Where?
The respondents.
Where entered appearance?
Before your Lordship.
This is the first time it's come up.
Yes, Your Lordship, but I have filed a miscase for condonation. So they have entered appearance, Your Lordship.
It's been condoned really?
Yes.
Miscase come here. So we listen to admission, but it's against the final order.
Yes. Lordship, here in the matter of concern, the crux of the matter involved is
Who
there's been...
responded? N.I. Chaudhary. N.I. Chaudhary. Yes, sir. You informed them, we'll have it next week.
Okay, yeah. Lordship,
Yes,
yes.
for Mr. Ringo, Leonard Council petition for the appellant stop the matter. This is admission. This is admission today. On the delay being condoned. However, there is no representation on behalf of the respondent. Respondent. Just after 1 week for admission.
Hello, Raj.
3. Item number 3.
Lordship.
Yes.
Lordship, this, Your Lordship, praying for some accommodation in this matter,
Why?
Your Lordship. Lordship, Mr. Sen has some personal difficulty today, Your Lordship. Lordship, it's long pending.
Yes, long pending.
Lordship, it's more
Lordship,
than 1 year now. We
He's
are.
enjoying interim order.
Small date may be given, Your Lordship.
Small date. Short date.
Short
not
date.
Small date. Yes.
Apologies, Your Lordship. Short date, Your Lordship.
Lordship, it may come next week, otherwise, Lordship.
Next week, yes.
Lordship, may the interim continue.
Mr. S. Council petition from
It may be the last chance, Lordship, because
Yes, let's after 1 week. Last chance has no meaning.
Lordship, interim may continue, Your Lordship.
Interim order is continuous.
I'll oblige, Lordship.
Item number 4.
May it please, Your Lordship.
Yes.
Your Lordship, that this matter may come up at the end of the board, Your Lordship, as the conducting counsel is in the next courtroom, Your Lordship.
let it come up after 2 weeks, Lordship, because I have to go to the other court.
What's the matter about?
It's a departmental proceeding, Your Lordship. Your Lordship, let it come after 1 week, Your Lordship, as there is some urgency in the matter, Your Lordship.
They've waited for so long, my lord. Let it be 2 weeks.
No, 1 week.
Much obliged, Lordship.
1 week. I request of the
Obliged,
council
Lordship.
petition.
5.
Lord, this matter is for admission hearing on the maintainability of the writ petition, Lord.
Where's the AG?
Coming, Your Lordship.
On the last occasion, Mr. Pandey had appeared. I think Mr. Pandey had appeared on the last occasion. So if the
I'm ready, my lord.
they'll have to open again, then, my lord, because some other counsel argued last time.
So I'm.
Because no, the things that you're questioning the maintainability of the.
There are 3 grounds on which I'm raising the maintainability issue, my lord. First is that the writ of mandamus has been sought by the political party, my lord, on the ground that some disturbance in altogether 4 booths in 2 constituencies have taken place, my lord. In 4 booths and in 2 constituencies, my lord. So my first case is that there is no violation of fundamental right.
Okay. Yes.
So there has to be violation of fundamental right, my lord.
Yes.
And without violation of fundamental right, writ is not maintainable. That is my first ground, my lord. If your lordship will have a look over my counter affidavit, my lord, which I have raised that point,
Because he's filing a preliminary objections, correct?
Yes, my lord.
It's not on the.
And we have touched on merit also, my lord, to an extent. But first, because if they succeed on this point, my lord, now if your lordship will kindly have a look at page 3, my lord. Page 3 is that it is a.
Yes.
Pertains to general election to JHADC and Autonomous District Council under 6th schedule of the Constitution. 6th schedule, which provides the provisions for administration of tribal areas in certain states, including state of Meghalaya in para 2, subpara 6 empowers the governor to make rules pertaining to district council and regional councils, including rules on any matter relating to or connected with election to such council. Paragraph 26F. In the state of Meghalaya, Assam and Meghalaya Autonomous District Council rules 1955 occupy the field of election to district council. Chapter 8 of the said rules provides for decision of doubts and disputes as to validity of an election. It is explicitly provided thereunder that no election shall be called in question except by an election petition. In terms of the provisions provided thereunder, the relevant provisions are, my lord, I have referred to 179 election petition, my lord. Save as otherwise provided in Rule 16 or in Rule 127, no election shall be called in question except by an election petition presented in accordance with the provisions of this chapter. The said provision, my lord, is pari materia to Section 10 of the Representation of People Act 1951 and carries forward the mandate of Article 329 of the Constitution, my lord. After quoting the Article 329, my lord, if your lordship will have a look on two judgments I have referred to in that paragraph 10, my lord. In Mohinder Singh Gill, my lord, and yes. I rely on in West Bengal Election Commission, my lord. So therefore, my submission based on this point is, my lord, that it is not open to it is not open to the petitioner to question the election on the ground of alleged violence in two booths for which re-election has taken place, and therefore there is no violation of fundamental right. If there is no violation of fundamental right, writ petition is not maintainable, my lord. My submission is short on this point, my lord. Then, my lord, second ground which I have taken, my lord, is that, my lord, that they cannot bypass the process. They cannot bypass the election petition by way of writ petition. And for the said purpose, my lord, I rely on the judgment of the Honorable Supreme Court, which is referred in paragraph 14, my lord.
Yes.
At first place, Article 329 of the Constitution bars any challenge to impugned election by a writ petition of 226 on the ground that the electoral roll on the basis of which impugned elections were held were invalid. I replace it with, my lord, that violence has taken place. The petitioner sought to escape from the ban of Article 329 by contending that they are challenging the impugned election as a whole and not any individual election, and that the ban of Article 329B therefore does not stand in the way of writ petitions filed by them challenging the impugned election. But we do not think this escape route is open to petitioners. This is in the Representation of People Act 1958. No concept of election as a whole. What that act contemplates is election from each constituency, and it is the election which is liable to be challenged by filing an election petition. It may be that there is a common ground which may vitiate the election from all the constituency, but even so, it is the election from each constituency which has to be challenged through the ground of challenge may be identical. Even where in the form of challenge is to the election as a whole, in effect substance what is challenge is election from each constituency under Article 396 must therefore be held to be attracted. So, my lord, Article 329(6) is clear provision, and 226 in my respectful submission, my lord, is not the remedy. And the paragraph 15 I refer to, my lord.
Yes.
I refer to the judgments where the Honorable Supreme Court have upheld the principle that the writ jurisdiction is extraordinary jurisdiction, and for failure of party to avail alternative remedy, it cannot be invoked, my lord. And the first judgment, my lord, it is the Constitution bench judgment I referred to in paragraph 16, my lord, that the jurisdiction of High Court under Article 226 of the Constitution is couched in wide terms, and the exercise therefore is not subject to any restriction except the territorial restriction which are expressly provided in the article. But the exercise of jurisdiction is discretionary, my lord. It is not exercised merely because it is lawful to do so. The very amplitude of the jurisdiction demands that it will ordinarily be exercised subject to certain self-imposed limitations. Resort to that jurisdiction is not intended as alternative remedy for relief which may be obtained in suit or other mode prescribed by the statute. Ordinarily, court will not entertain a petition under Article 226 where petitioner has alternative remedy without being unduly onerous, provide an equally efficacious remedy. Again, the High Court does not generally enter upon a determination of question which demands an elaborate examination of evidence to establish right to enforce such a writ, enforce which the writ is claimed, my lord. So the point which I am trying to make, my lord, is this, that under Article 220 they have remedy, they had remedy under Rules 179 which I have quoted, my lord, in my counter affidavit at page. They could have filed the election petition challenging the election in respect of two booths if they were really aggrieved. But on the facts of the case also, my lord, it will be demonstrated that there is no case of.
Now another thing is that there was allegations of violence, yes, whatever.
Yes,
repolls were held in those stations.
Yes, my lord. That you will also will find at page paragraph 17 at page 8 where I have dealt with that aspect also, my lord.
Yes.
The petitioner in the present case, paragraph 17 at page 8, VPP is particularly aggrieved by conduct of election at 4 polling stations, my lord, out of 4 in 2 constituencies, my lord. We have got more than 34 constituency in 34 in 2 constituency in 4 polling booths. They had grievance, my lord. 7 Wangpunkar male and 8 Wangpunkar female. At 22 Musiang Rangat district council seat, and 7 Batao A male and 8 Batao B female at 29 Batao Lakadong constituency. It is pertinent to point out that district election officer East Jantail reported the incidences of mob violence at the said polling station on the day of election itself on 21/2, and consequently in terms of Rule 143B of Assam Meghalaya Autonomous District Council Rules 1951, a repoll was declared and smoothly conducted on very next day on 22. Further, the said intent were investigated and a FIR was registered, my lord. In the light of a pursued factual scenario, it is most humbling nothing remains in terms of relief sought by petitioner under 226. At best, appropriate remedy of the petitioner was under repolling under 143B of the rules, which has already been successfully conducted and results were duly declared. Further, petitioner is not even aggrieved by repolling and has not called the same into question at any point of time of present application. Thus, it can be duly inferred that all relief that petitioner could have claimed in the factual matrix have already been received by me. And then I rely on certain judgments, my lord, in paragraph 18, which says that the courts do not entertain a case which does not raise a live issue, my lord, and I have referred to those paragraphs. Now, paragraph 19, my lord, is with regard to prayer 3 of VPP, my lord. If your lordship would see the prayer of in the writ petition, paragraph 19, they want certain policy, etc., to be laid down, my lord. Yes. Yes. If your lordship will have a look at page 11. 3. Issue appropriate direction for formulation and implementation of stricter guidelines to ensure safety, security, and fairness of future district council election in sensitive areas, my lord. Now, this is the third prayer prayed by the political party, my lord. By way of prayer 3, the petitioner has called upon this honorable court to step into the domain of legislation, paragraph 19, my lord, to formulate policy guidelines for conduct of elections, particularly when Assam Meghalaya Autonomous District Council rules already occupy the field and same is thus impermissible. In the case of VK Nasawa versus Union of India, the Honorable Supreme Court in clear and categorical terms had observed We do not issue direction to the legislature directly or indirectly that any such direction if issued would be improper. It is outside the power of judicial review to issue direction to the legislature to enact a law in a particular manner for the constitution does not permit the courts to direct and advise the executive in matter of policy. Parliament as the legislature exercises this power to enact a law. So this is the judgment, my lord, and the same is on next paragraph, Ashwini Kumar versus Union of India, my lord, where that judgment of weekend Naswa in last line, if you also will see at page 10, has been referred to, and the same principle has been reiterated. I have extracted the relevant paragraph, my lord. So in my humble submission, my lord, the case of the petitioner,
first, no violation of fundamental rights. Second, cannot bypass electoral process.
Alternative policy. And third is that this direction is, and on merit, if you lordship will kindly see the writ petition also. What is the grievance, my lord? I will just take your lordship to one or two pages where they have given certain representations, and those have been taken care by the department also, my lord. If your lordship will have a look on that part also, my lord.
The objection was to the maintainability, my lord.
That's all right.
Only on the merits, I will have to open, my lord. On the merits, I will have to open.
I will just show in the context of maintainability only. This is in the context of maintainability, not outside the maintainability. I am on the issue of maintainability, page 17, if your lordship will see.
We'll decide maintainability first.
Yes.
If the court considers to be maintainable, then yes, we will, my lord, go on merit. Otherwise,
Yeah.
but you can touch upon the merits.
Yes, slightly for the purposes of maintainability only, my lord. For the purposes of maintainability only, I will touch not because I have not gone in detail, my lord. But
the affidavit also doesn't address
one paragraph we have said so, my lord. Now, if your lordship will see the first letter which is written by the secretary of is 11-2, my lord. That is at page 17, my lord. This letter formally expresses our grave concern. Give me the dates of election. That is list of dates. Yes, my lord. If your lordship will see the letter, the petitioner has written to me to the election to the returning officer. Of your lordship will kindly note in charge of 8 Mudop Umladang District Council. Your lordship has note, and in paragraphs 19 of my counter affidavit, because the violence has taken place, your lordship has noted that in there are 2 constituency, my lord, Musiang Rangkat District Council and Batao Lakadong constituency. This is, but the apprehension they expressed, my lord, was with respect to Modop Umladang District Council, my lord. In the letter we received information villages ahead, so there is so far as this constituency is concerned, my lord, there is no grievance in the entire writ petition, my lord.
Okay.
So this is something, because and there is no violence, nothing in this constituency, there is no grievance of the petitioner. So in 4 booths of 2 constituency, alleged violence has taken place, my lord. And if you lordship will see the next page at 14 February, my lord, the sensitive woods which they indicate, my lord, subject to correction, my lord, I do not find the constituency where violence have taken place is in the part of the letter of VPP, my lord. So it is a kind of red herring, my lord.
Yes, will not be.
Yes, and my lord, if your lordship will, so therefore, and then the answer, if your lordship will see, those replies have been given by department also. If you department's reply only, I will just flag those replies, my lord, and that is at page 28 of my in the writ petition, where we have detailed, is part of their writ petition only, my lord. Page 28. Your lordship may have a look on the reply also, where we have taken care of the concern raised by the people.
The district council elections are governed by the rules, which is Assam and Meghalaya Autonomous District Council, Constitution of District Council Rules, 1951. I have handed over a copy. Yes. Now, my lord, as submitted by the...
May I take, my lord, my...
Yes.
As submitted by the Learned Advocate General, these rules are parameteria to the Representation of People's Act.
Okay.
Now, The Representation of People's Act, my lord, election petition is provided under section 80. And the rule parameter to section 80, your lordships will find at rule 179. These rules, my lord, are as good as copy paste of the election Representation of People's Act, my lord. Now, section 179 provides for election petition. Section 80 provides for election petition. And the subsequent rules also, my lord, they are exactly similar, ditto, my lord. So, my lord, if I am to challenge an election, I will come under Rule 179, my lord. But in my case, my lord, we are not challenging the outcome of the election. We are on a totally different footing. As a party, my lord, we made representations and the representations were not considered. We have called for inquiry. Now, my lord, what I am trying to invoke is, my lord,
I think that it concerns an election.
Yes, my lord.
Whatever grievances arise from election,
Yes.
whether you're not challenging it specifically like every constituency, or you're just saying you have a grievance with the way elections were conducted. Correct?
Yes, my lord.
Which had you, according to you, had an impact on the results. Correct?
No, my lord. We have got nothing to do with the results.
You don't have
No,
any
no. Our grievance is
concern with the
proper conduct. Why, my lord? Now, my lord, kindly have Rule 207, my lord. Before 207, my lord, I'll take your lordships to 206 and your lordships may kindly have Rule 136. Section 136 is paramaterial to Rule 206. All these provisions are paramaterial, my lord.
Yes.
So 206, my lord, Rule 206, other offences and penalties thereof.
Yes.
And section 136 of the Representation of People's Act.
Yes.
Now, my lord, kindly have Rule 207. Prosecution regarding certain offences. This is where my case is, my lord. Rule 207(1) says, if the government has reasons to believe that any offence punishable under Rule 199 or under 204 under clause so and so has been committed with reference to an election within an autonomous district, it shall be the duty of the governor to cause such inquiries to be made, as such prosecutions to be instituted, as the circumstances of the case may appear to him to require. This is what we have made a representation to the government. Now, 207, my lord, is paramaterial to 137, section 137. These rules were framed in 1951, my lord. Section 137 was omitted in 1966, my lord. I'll just hand a copy of the amendment. If your lordship comes to this next page, 61, my lord, omission of, middle of the page, omission of section and savings. And it says, my lord, provided that such omission shall not affect any inquiry or other proceedings under the said section pending immediately before such omission, and any such inquiry or other proceedings may continue. So, my lord, the process of inquiry was under section 137 before it was omitted, my lord. Now, this omission is not under the rules. It still exists under the rules. Now, after omitting section 137, what was done, my lord, if your lordships kindly have the Representation of People's Act, chapter 4 of the Representation of People's Act was my lord, inserted, my lord. Chapter 4, my lord, deals with election commission, my lord. So if your lordships kindly see this chapter was inserted in 1965 by the Amendment Act of 17 of 1965. Because the election commission was inserted, my lord, powers were given to the election commission, so section 137 was omitted. So now the power lies with the election commission for any kind of offence. In this case, my lord, under the rules, there is no such omission. Rule 207 still exists. I am entitled to make a representation to seek for an inquiry. I have come before your lordships only for direction to the state to consider. I am not seeking for a mandamus, my lord, to say, okay, conduct an inquiry. I have made a representation, my lord, they have to look into it under Rule 207. That is my case, my lord. I am not challenging the election, the outcome of the election, my lord. General elections and state assembly elections, my lord, are conducted by an independent body, my lord, that is the Election Commission and the State Election Commission, my lord. Here the district council elections is held by the state government, my lord. So the only question we are raising is, the only request we have is to kindly conduct an inquiry. We had apprehensions, we made representations, no proper care was taken. That is why those 4 repolling had to happen, because there was no proper security. And there's no independent body to, my lord,
election.
Yes, my lord. So that is my case, my lord. That is why I'm saying this matter is maintainable, my lord, under it. It is not that I'm challenging an election of a particular constituency, that individually that person will have to come and challenge. The party has to come because it involves overall, my lord, issues. So that is my case, my lord.
So how do you now answer the query of the Advocate General regarding the violation of fundamental rights? I mean, you say that under the rules itself has vested you with the right to approach this court.
Yes, my lord. We have made a representation. We are required to be heard, my lord.
Yes.
The rules provide.
So according to you, you're not calling the elections into question.
No, my lord.
You're not calling question.
No, my lord. All we want is.
What's the question you have then? It's a part.
The question is, my lord,
part and parcel of the election process. Now, if you're not going to call elections in question, then you'll have no grievance. You'll have no grievance at all.
My lord, the grievance.
The thing is that the grievance of the petitioner is with the conduct of the elections. Now, conduct, you see the definition is defined, the conduct of free and fair whatever elections. Now, if you're not aggrieved with you say you agree with a portion of elections, you're not bothered with the results, but you're bothered with conduct. But isn't the conduct of elections part and parcel of the entire election process?
Right, election process, but not an election to a particular constituency, my lord. I'm not challenging the election process of a particular constituency. I'm saying overall elections, my lord. Overall, there's no independent body, my lord. It's the state government who's conducting it.
So you would be satisfied if the direction is issued that they would examine what happened in those elections at this point of time?
No, Lord, I came immediately after the elections.
Yes, I mean at a point of time. Of
yes.
A lot of water will flow under the bridge because by the lapse of time. Now, do you think that will serve any purpose?
Well, Lord, it will serve.
In which way?
It will serve, my lord, because there are going to be future elections also. That is why we have sought for some kind of guidelines, my lord, to ensure. In general elections, in the assembly elections, we have the election commission. Here we do not have an independent body. Therefore, we require some guideline, my lord. So that is my case.
Pass orders.
Yes. Deeply.
My lord, if I may. I think the Meghalaya Code of Conduct for elections is already there, my lord. It's,
what elections?
Vote for.
Model code is different. That is for. You produce it by end of today only.
My lord, I'll do that.
If you see the model code of conduct for district council elections.
We'll do that, my lord. Give me time, my lord.
By lunchtime you produce it, yes.
Item number 6.
Hand it over to the court master. Yes.
Please, Lordship, I am taking further time to file my rejoinder, my lord. In this.
How many times you've taken?
I think this only is second time.
Lordship, I'm for respondent number 1 to 4.
Your objection?
No, Lordship.
Use further 2 weeks time as prayed. Roughly joined up. List the last one, so and so.
7.
Merciful Lordship.
May it please your Lordship. Your Lordship, in this matter, the pleadings have been completed. The rejoinder affidavit has been supplied.
We can dispose of now. What is the contempt about?
Your Lordship, this pertains to the violation of the by the
You
contender.
No, Your Lordship, no contempt is made out against me. Lordship, because here the petitioner is trying to dispossess me from the sued land, and they are trying.
The matter?
Your Lordship, I had filed my rejoinders. I'm praying that the matter may be listed for hearing.
You won't hear it. What's there to be heard? You are Mr. L. Kriam?
Yes, Your Lordship. I'm in the same chamber, Your Lordship.
You're in possession? Who's in possession of the land?
It is in my possession. They have started to raise new construction within the sued land, so the police came and stopped them. So after the police came, they filed this contempt.
You're not in possession of the land?
Your Lordship, we are in possession of the plot of land, Your Lordship.
What stage is the suit?
Your Lordship, at present the suit is at the stage of issues.
Has not been framed, Your Lordship, till date.
When was it filed, the suit?
In the year 2014.
2014?
Yes, Your Lordship.
No, issue has not been framed?
Yes, sir.
No, Your Lordship.
That is why, Your Lordship, earlier this honorable court has passed the order to maintain status quo. So after the passing of the status quo, they are trying to make new construction within the sued land. So trying to dispossess
and file contempt against you.
Yes.
You know, we will hear it. Yes, party 7 is complete list after one week. Yes.
8.
Lordship, in this matter, I'm praying some more time to file the affidavit.
Same parties?
No, Your Lordship, this is pertaining to the district council service matters, Your Lordship.
Yes, as paid for the 2 weeks time allowed for affidavit.
Obliged. Highly obliged, Your Lordship.
9. Item number 9.
It's not appears for the parties just after 2 weeks. Yes.
10.
May it please your Lordship. Lordship, I'm praying for some time, Your Lordship, to file our affidavit, Your Lordship, for the state respondents.
Why so long? This was filed since. What's the matter about?
Demolition.
Promotion, Your Lordship.
Demolition?
No, promotion. It's about promotion, but cancellation of the promotion, Your Lordship.
Why not filing the
Your Lordship will be filing, Your Lordship.
the course of the day? Why can't it go on like this?
2 weeks time may be given, Your Lordship.
Who's the leading counsel? You're arguing the matter? When are you going to file? 1 week?
2 weeks time may be given, Your Lordship. Positively, we'll be filing on the next date, Your Lordship.
I don't want praise for 2 weeks time to file after she further undertakes that the after be filed positively in the next date. Yes.
11.
Much obliged, Lordship.
Affidavit, Dr. Mozika.
Bring some more time. last opportunity may be given, Lordship. I have filed my additional affidavit in the month of October, and this is January, Lordship.
October is closed after that.
For the 2 weeks time is period allowed. Yes.
12.
May I please, Your Lordship? We are seeking some more time, Your Lordship, to file a reply to the objection filed by the state respondent.
Why some more time? How much time is? When is the
This is the
objection
second time, Your
filed?
Lordship.
You file objection.
Yes, Your Lordship, to the miss case.
When is it filed?
This is second time, Your Lordship.
When is it?
28th.
Not second time. When is the objection filed?
In November, Your Lordship.
You sought impleadment.
Yes.
Then we allowed objection. We are not filing affidavit.
Second chance, Your Lordship.
Not second chance or third chance. What's the difficulty in filing an objection? Okay, we give final opportunity. It's final opportunity of 2 weeks allowed to the petitioner to file objections to the your updated petitioner. Yes, to file reply to objection to the impleadment petition in miss case number 320/2025. Yes.
Highly obliged, Lordship.
13.
My lord, so far service report on respondent number 15, my lord, will be filing, my lord, as soon as we get a report from the post office. The rest are all completed, my lord.
My lord, we'll file a affidavit, Lord.
And my lord,
we'll file affidavit. My lord, this matter has actually been endorsed to Miss Seema Parsaji.
That is not the court's concern.
My lord, I'll have to take steps.
My lord, what I like to
PU been submits that the
just small prayer, my lord, that I want to give, my lord, is affidavit they'll file in the course. It's okay, my lord, but if my lord may kindly direct them as to whether they are considering my grievances or not, because now there's a concern of promotion, my lord. I am additional SDSEO. I am the additional SDSEO, my lord. And all my juniors, my contemporaries, they've all been promoted, my lord.
we will need affidavit for that.
My lord, but my lord, if they are generally considering my case, my lord, then the matter may on the next day, matter may get closed also, my lord, because now there are only 3 seats available, my lord. One SDSU in Shillong.
Have you got a parallel comment?
My lord, the Contempt Council is still recovering, Lordship. I'll have to take.
Have you got any parallel comments yet or not?
My lord,
they have not.
Then?
They have not.
I don't have the brief with me, Your Lordship. I have to take fresh steps.
Mr. H. Karanlang's praise submits that due to the illness of the contracting counsel, he is not in a position to apprise of court as to the status of the case. He prays allowed 1 week's time to obtain instructions.
1 week's time. Obliged, Lordship.
Further, Mr. P. Ubin also to ascertain the status of service on the form
15, my lord,
and to file affidavit in this area.
My lord, obliged.
14.
14 till 23, my lord, for affidavit. The fresh matter.
Yes, as per it, further 3 weeks time allowed for affidavit. Yes.
Till 23.
Yes.
Second call.
Supplementary license.
Item number 1.
Candy have item number 2. These are connected matters. 1 and 2. But Candy has number 2 first.
Number 2 first.
Number 2 is
Bari Laginti.
Balari Kinti Lindem.
So Lordship kindly comes to page 24, my lord. This is the RCW scheme of the government of Meghalaya.
Yes.
So I wanted to point out that serial number 3, my lord, which says that a casual worker who has immediately before the date of coming into force of the scheme been working as such for a continuous period of not less than 10 years may be conferred with the status of RCW, my lord. And then it says, my lord, number 5, serial number 5, when vacancies in Group D post arise in any department or office, 50% thereof subject to rules and orders and the instructions reserved for RCW, my lord. And then at serial number 6, my lord, what you will see, an RCW shall cease to be employed on his attaining the age of 58 years. So, my lord, at that point of time, the retirement age was 58 years, my lord, for RCW. Now, my lord, pursuant to this, page 27, your lordship will see, the petitioners who are...
You're the petitioners here?
6 of them, my lord.
Yes.
Were conferred the RCW status, my lord.
The petitioners before this court, they were already RCW.
Already RCW, my lord. I can point out they are at serial number 37, 40, 45. Okay. So all 6 of them are there, my lord. Now, at page 32, your lordship will see, this is 4th May 2009. The Governor of Meghalaya is pleased to specify that the upper age limit of casual employees, muster roll, daily wage workers in a government department, corporation itself should not exceed 65 years. So the retirement superannuation age was enhanced from 58 to 65, my lord.
Okay, yes.
Now, as I pointed out, my lord, RCW scheme says that on completion of 10 years of service, RCW and 50% of this Group D post. Now they are serving, my lord, if I take your lordship to their service profile, my lord. At page 71, my lord, kindly see, they are serving for over 30 years, my lord.
Years. What do you want now?
Now, my lord, what government has done, they have reduced the retirement age again to 58 years, my lord, by the impugned order. Now, my lord, there are 2 aspects. Either they should have considered us for regular status, my lord, or in Group D post, which they never did for 30 years, my lord. They cannot say that in last 30-35 years, no vacancies arose in Group D, my lord. Now, my lord, the petitioners are happy at least because if they are absorbed into Group D, they'll retire at 58. So, on this hope that at least they'll be allowed to continue till 65, they continued, my lord. They did not approach this honorable court. Now, what they do, they deprive them of regular status of Group D also, my lord, and then now they reduce the retirement age also, my lord. But so I'll take you, lordship, to the impugned order, my lord. Page.
36, 37.
Page 36, my lord. This is 25th September. This is the same day that SOP was issued, my lord. But this is a very critical date, my lord, on what happened on that day. It says, my lord, the government of Meghalaya is pleased to add a proviso to so and so, provided no person shall be employed for doing the work on a daily wage basis who have not attained the age of 18 years. That is okay, my lord. Then it says, no, notification number 4th May 2009 is denotified. This shall come into force with the date.
RCW scheme. I mean, 65 years.
65 years.
Denotified.
Denotified, my lord. Now, my lord, they've issued a letter to us, page 75, lord should see. This is 19th of December. Addressed to us, my lord. We are some of the address here are us, my lord, the petitioners.
Yes.
It says clarification on retirement age of casual employee muster rolls. In continuation to the letter number under referred, it is informed that the date mentioned in this above referred letter was inadvertently stated incorrectly. The error is regretted. The correct date for the discontinuation of your engagement on daily basis under this division.
What was correct? What was written incorrectly?
My lord, the government will be able to clarify. But it says, my lord, our 31st January 26, which is day after tomorrow.
No. What is the continuation letter and under reference? That the date mentioned in the above referred letters inadvertently. Errors is getting.
My lord, we don't have a copy. We try to get a copy of this, my lord.
But what is letter about? What error is this? Regarding retirement age.
Now, my lord, because I don't have in my possession this letter. But the fact remains, my lord, we were deprived of both the benefits of RCW status, my lord, of the scheme. And whether
no Group D status has been deprived.
We were happy even if government did not give. We will continue till 65, my lord. Now
so you have crossed 58.
We have crossed 58, my lord. All of us, my lord.
Then what puts them in between a rock and a hard place? Like
I will just. But the question, the legal issue that will arise, my lord, whether a vested or accrued right under the 2009 can be taken away such unilaterally, my lord. And they are poor people, my lord, serving in lordships in RCW, 19,000 rupees per month, my lord.
Oh,
Mr. Advocate General,
yes.
What is your instruction?
Yes, my lord, because now there are two things, my lord. I will, the case of the petitioner, which what I have understood is that, my lord, that the earlier their age of retirement was 58. The government revised the age of retirement to 65 in 2009. Now government has decided to now make the age of retirement for RCW to 58 million. Now the question is that the power of the government, so far as the retirement age is concerned, my lord, in government employment, your lordship is aware, lies in the domain of the government. It's a policy decision which is the government has taken.
What do you say about this?
Now,
what the correct date? So you just en bloc retiring them?
Yes, my lord. That if your lordship will appreciate that so far as the service jurisprudence is concerned, my lord, today I am in government service. Today I am in government service, and government takes a view in certain states. It's the age of retirement is 55, my lord. Age of retirement is 55. In certain states is 60. In Meghalaya is 58, my lord. So far as age of retirement is concerned, or your continuation, because this is not a punishment, this is not a termination in line or in the light of some stigmating action, my lord. It is a policy decision which government has taken, that in tune with all government employment, retirement age has to.
See, the thing is that
so therefore
we have to take into consideration the fact that you are appointed under this scheme.
Yes, my lord.
They've been working 10 years.
Yes,
for the scheme came to be.
Yes, my lord.
Then they were covered under the 65 years.
Yes, my lord.
Yes. So now, have not acquired any vested right? Can be taken
yes,
away?
now that is the question which your lordship will have to. No, your lordship will have to decide whether the employees in the government service, has a vested right to.
Because you look at the conditions, they are not covered by any rules. They don't have any protection also.
No, the question is no, in government. The question is, my lord, if your lordship will see from different angle, the question is in the government. This is a service by virtue of the certain executive actions of the government, which they have to term it is arbitrary. Because if they say that, look, the government is not right in deciding that age of retirement should be 65, 58, 59. I should have say in my age of retirement in government service. With greatest respect, my lord, that is not the law in service jurisprudence. The service in service matters, my lord. The age of retirement is determined by the government, my lord. Today, government can say, I will fix the age of retirement as 55.
Fine, if it's fixed on the beginning 58, you stick to 58.
But now the question is with.
But now, see, policy decision, well and good.
Yes, my lord.
But then what about the decision being processed?
Yes, my lord.
Now how he arrived at the 58?
Yes, my lord. So now the second part. First part, the legal part, and the second part, what is the impact and how it is going to affect them, my lord. Now the question is, my lord, that earlier they knew that their age of retirement is 58. Which was enhanced to 65, my lord. Casual workers are there, my lord. They have to do the menial work.
Yes.
They have to do the menial. They were getting they will have to earn 58 to 65. Government deemed it appropriate, my lord. If you also will see one page only, page 71. First candidate will also will 61 years of age, my lord. First candidate only, you also will see fixed 61 years he has already completed. And he has already served 35 years of my lord. Now he says that I have a vested right to serve the government till 65. Because earlier you have enhanced the age of retirement to 65, my lord. In my humble submission, nobody has vested right to claim that I should serve the government You can serve the government as per rules and policies which are in existence, and you have to show that those policies are
preserve the government.
Because even in certain cases, my lord, if age of the retirement employees have been reduced from 58 to 55, my lord. In those cases, all those who have crossed 55 have to go. There are numerous instances. I will take instruction, my lord. Lordship will examine this matter. What is the issue? And because this has got
31st January is
my lord, now it would amount to giving them entire relief. We will file a short affidavit, my lord. If they succeed, they will get the benefits under the order of the court. They will get salary, my lord.
Can the SAG is almost sacking from service by giving
now my friend is asking
19th
for
December order?
Question is, my friend is asking for interim relief to continue beyond this notification. Then your lordship, first the issue is that whether this is a final relief which they are asking at the interim stage. First, they have to say that this policy is bad in law. The government is denuded of power to reduce the age of retirement from 65 to 58. Prima facie case they have to establish. They are not quarreling or they are not questioning the power of the government. They are saying that look, certain disadvantage has occurred to us. Now, if at all they will succeed, your lordship has got ample power to direct the government to compensate them regarding salary. Your lordship has ample power to say that if the policy is held to be bad in law, the lordship will say that they are entitled to this. But if my policy is kept in abeyance or stayed at this stage, my lord, and your lordship comes to the conclusion that the policy is valid in law after hearing the parties, my lord, then the state can't recover the money from them. Okay. So the balance of convenience, in my humble submission, is whatever is outcome, your lordship can reserve that kind of direction, that in case they succeed, they will be compensated by the state government. But this policy as on today, in my humble submission, is as per law, my lord, is as per there is nothing wrong with this policy, my lord. And your lordship is aware that after 58, 59, the groundwork, hard work is not possible, my lord. So it is in public interest also.
Why in the first place?
So this was, my lord,
1065.
So that was the error which committed, which we have corrected it now. After our experience, of the working of this scheme, we realized, your lordship knows that in administrative matters, there are some things which we have to see in working. It's basically we work and we learn from our own mistakes, my lord. If they have the certain vested rights.
Order dated when impin order?
And if you lordship, December, my lord, is in the December and
19th of December 25.
And December, my lord. So therefore, at the fag end, they are saying. They could have come in the vacation. We could have filed the reply. They want to come only.
If I come in vacation bench, the objection is raised. Why vacation bench?
Now, see, my objection is being thought. My lord, so kindly see this.
Reply, my lord. I'll give a very short reply. Whether such reduction of age can be retrospective or can it apply to those who have accrued some vested rights?
It can be retrospective. There is no.
Second aspect,
it is being applied with effect from today.
Second aspect, my lord. Can balance of convenience be pitted against right to livelihood, my lord, which is a fundamental right under Article 21, my lord? The balance of convenience is purely a matter of procedure, my lord.
Right to livelihood, my lord, will extend to each and every citizen of this country, my lord.
So it's a balance.
And everybody, I can't. And those who
and this is the fittest case, my lord. Your lordship will.
Those who have retired after 58, right to livelihood.
When can you file the affidavit?
1 week, my lord. 1 week, maximum 1 week. We'll file.
Okay. Yes.
Number 1 is also similar, my lord. The only difference, my lord, these are RCW status confirmed, my lord, and number 1 are muster roll, my lord.
Yes, heard Dr. Elmo's counsel assisted by so and so. Issue notice. The Advocate General with so and so is present on behalf of the respondents. All the respondents, no further notice required stuff. The grievance of the writ petitioners was stated to be regular casual workers appointed under the Meghalaya regular casual workers scheme 1996 is with the abrupt Oh, is with the notification dated 20
25/9/2025.
25/9/2025, whereby where's 65 years in?
Well, 65 years is at page 32, my lord.
Whereby an early notification dated
4th May
4/5/2009, page
32.
32, has been denotified, wherein which provided for the retirement age to be 65 years. It is submitted like Parabellum Senior Council that thereafter the state respondents
32, my lord, kindly see 32 should not exceed 65 years. It's not that it should not exceed.
It's your own document.
Specify the upper age limit. What is the
should
meaning
not exceed 60. It is the upper age limit. So it can be before that also, my lord.
65 years. Yes, Learned Senior Council has submitted that. Where's the last order we asked to retire? Is the council
Page 75.
submits that the state respondents, in pursuance to the said notification dated 25/9/2025, have issued a letter to the writ petitioners and others informing them about the discontinuation of the engagement on daily basis with effect from 31st January 2026. So, it has been contended that the writ petitioners who have been serving for long years as RCWs have acquired a vested right by virtue of the notification, wherein the upper age limit is fixed at 65 years, and that by the letter dated 19/12/2025, this right, this acquired right, has been sought to be taken away by the state respondents without affording any opportunity or reason. Stop. I therefore praise that in the interim, that it prays that the petitioners be given some interim protection as the date for which the for which has been as much as the date for disengagement has been fixed on 31st January 2026, which is 2 days away. Top. Next paragraph. The Advocate General, appearing for the respondents, has counted the submissions and replies counted submissions and reply submitted that the fixation of the upper age limit is strictly within the domain of the state respondents and is a policy decision which is not subject to scrutiny, not subject to judicial scrutiny. It is further submitted that the writ petitioners themselves have already rendered long years in service, and some have already
crossed
58 years.
Yes, all of them.
And as such, are not affected in any manner. Staff submitted that the panel of convenience lies squarely in favor of the respondents for the employers, and has reiterated has reiterated that the decision that the same is the policy decision of the state respondents. This court, on hearing the counsels on the pericontent, on hearing the counsels is concerned with whether the prescription given by the impugn fixing the reducing the upwage limit can be retrospective, and also whether by virtue of the long service the petitioner acquired the vested right to continue as per the earlier notification. So, in these circumstances, it is necessary that the respondents put in an affidavit to clarify the position as to the reasons for reducing the age limit and whether the same can pass a test of reasonableness. Yes, accordingly, in view of the fact that the date fixed for disengagement is 31st January, it provided that until the next date, the petitioners shall not be disturbed in their service. So when can we disturb?
2 weeks, my lord, then 2 weeks.
See, the paying daily wage, it has no effect on you. If you work for 10 more days also is nothing.
2 weeks.
You can, yes. No? Or when? 2 weeks.
2 weeks, my lord.
No? Yes, sir. The instructor responsible to file this matter after 2 weeks. Also.
Counter and rejoinder also, so that pleading matter can be
filed. Yes. The only thing is that you have to. But as it is, they've served more than 60 years. That Group D thing also, yes.
Never given the benefit of Group D, my lord. Had they been given the benefit of Group D, my lord?
They were retired by now.
But they would have retired with pension, my lord.
That is
number one, the only difference they are muster roll, my lord, and number two, they are RCW. That's the only
there will be some legal muster role will have different position, legal position.
No,
but we will.
The impugn order talks about the enhancement, my lord. Page 32 talks about all of them, my lord. Page 32, lords, so kindly see, my lord.
Yes. This Silbida. Yes, sir. Page 32.
Silbida. Silbida page number. Silbida just take out page number. Here page number.
Petition.
Page 27, my lord.
Oh. Yeah.
It says, well, government of Meghalaya is pleased to specify that the upper age limit for casual employees, muster roll, daily wage workers. So for all across the board, it was enhanced to 65 minutes, including muster roll.
This instant petition is similar to WPC number. For the moment,
7.
So 7/2026. And the facts one can see are identical, but only that it refers to muster roll workers. The interim orders passed in WPC so shall also apply to the present petition, to the instant petitioners in the next date. Yes.
Yes, my lord. Now, in this matter, my lord, that is huge, my lord.
See, one thing.
Yes, I understand that there was an order passed by this, your lordship, staying the.
No, we don't know what are the contents of the appeal, even division.
No, because what has happened in batch matters, my lord, there was an order in all those matters challenging the cabinet decision against the regularization, my lord. So one of the Chesterfield Suja was and 9 others, and they filed a writ petition, and your lordship has passed those interim orders which are now listed for 6th February, my lord. 6th February. Now, in the meantime, in terms of the division bench order, the advertisement was issued, my lord. Now, because there is a stay granted by your lordship in respect of 9, and 6 have gone to the division bench, my lord. Division bench again 6 we went to division bench. Division bench passed the order directing us to issue the advertisement, my lord. Now the issue is that so far as 9 is concerned, there was no challenge to your lordship's order before the learned single judge, and that order was also not in our notice when we argued, because otherwise we would have placed that order. Now the situation is that advertisement has been issued. I have spoken to the department also, because there is a stay operating qua 9, my lord, in respect of 9 passed by Your Lordship, and Your Lordship is examining the entire matter whether they are entitled to regularization or not. So Your Lordship stayed whatever we
stay there.
Stays the
yes, my lord. The thing is that one thing is what
ultimately all these.
See, what has happened here is it's a very strange kind of situation.
Yes, my lord.
Now contempt was proceeding after it was filed.
Yes,
second after it was filed.
Yes,
then a writ appeal was filed after how many years?
After 1 year almost. Yes, my lord.
More than 2 years.
After 1 year, my lord,
and
because
after that also the order also is not very clear.
Yes, my lord.
What draft? What adjustment?
Yes, my lord. Those are the Your Lordship. What the ultimately the larger question
is, and they were not parties there before the appeal.
No, so far as 9 are concerned, they were not parties. 6 because they only 6 came. Now, so far the larger question which Your Lordship is deciding on 6th or whatever date is that whether they are entitled to regular.
First, you have to segregate the others, that A&M, JNM, which you have already given the benefit.
So then,
now that you have segregated that before we proceed.
Yes, we can go into the other. Whether they are, if there are others.
Now, sericulture is one batch.
Yes, ma'am.
Then the other batch of which department?
Water Resource Department.
The Forest Agriculture Department. There are other departments.
So other departments are not covered by your cabinet decision regarding A&M, JNM.
A&M, JNM. So Your Lordship will have to have a look.
The paramedics have not been covered.
So Your Lordship will have.
6 that we have to segregate that first.
Yes, we have to
segregate. In fact, we are filing an affidavit to bring on record the notifications which
and then segregation has to take place.
But has the cabinet decision been notified?
Yes, my lord. I have seen in the newspaper. I have not received
it. Kindly file by affidavit. From state respondents.
Yes, I'll file that.
So that's on the 6th.
Yes, my lord.
Anyway,
so in this case also Your Lordship stay and put it in on 6 only, my lord. Ultimately all these matters will go in together.
Number 3 is contempt. Number 4.
Contempt will have a main appeal.
Yes.
The President first will not issue notice of contempt.
Page 113 is the advertisement.
The notice will go to the other respondent also, and the other respondents for
state only. State MPSC is a
Page 113.
MPSC. Page 113 is the advertisement.
MPSC.
When the matter is taken up, the Advocate General has fairly submitted that the larger issue is still under consideration by this court with regard to the service of the petitioners. In WC number
555.
WC number 555 of 2025, which is tagged with other connected matters. Stop. Next paragraph. Dr. N. Muzika, Leonard Singh submitted that the issuance of the advertisement dated 19/12/2025 may come in conflict with whatever finding or judgment that may be passed in the other matters. Stop. Accordingly, considering the court to avoid multiplicity of proceedings, further multiplicity proceedings and complications, the impugned advertisement dated 19 December 2025 shall not be given effect to until
555 is heard.
Until 555 and other matters are heard. This together with on 6th February.
6th February with the batch matters.
4th February.
4th February.
The contempt list lang.
Hearing 26.
Yes. MSP Chitri. Yes. Yes. Can't hear you. Are you muted? Yes. Can't hear.
Mr. V. Kumar seeking time only.
You can lip read. I can't make out what you're saying.
Mr. V. Kumar in the earlier order.
Yes.
In the earlier order, Mr. Patak and Mr. V. Kumar.
Who's this lady?
Appearing on their behalf.
Yes. What's happened to your? When?
Next week. After 2 weeks.
Yes. Just after 1 week, yes. Yes, on the request of the counsel, the petitioners are on the
29. 29.
The matter has travelled to the Honourable Supreme Court. Matter is now listed. Where is the order? Matter is now
Your Lordships will have to pass an order transmitting the records to Supreme Court. Your Lordships.
In view of which order? Is that court staff matter?
Yes,
councils, other parties have produced an order dated 15/12/2025, whereby the records of the petition have been called to be transferred to the Honorable Supreme Court. Accordingly, the matter shall then transferred the registry to take action expeditiously. Yes.
Both the matters, my lord.
Both the matters, common order.
Common order.
35. 35.
Please, Lordship, as for the order date 3/12/2025, I was given an opportunity to find the rejoinder, Your Lordship. Yes, during vacation I could not find it. I am seeking, praying
to close the joinder then. How it's come for hearing? Why are you finding joinder now?
Actually, it was mentioned rejoinder as well as for hearing.
You're for the petitioner?
Yes, for the petitioner.
The way he's standing?
Yes. Yes, I'm for the petitioner. I'm for the petitioner.
Both were respondent.
Respondent.
Where's private respondent?
Private respondent, Mr. Hassan was appearing.
Allow him one opportunity for the joinder or do the hearing stage.
Yes, give me last chance because on the holiday I was.
No, not holiday. I mean, why rejoinder hearing stage?
Because some things they have make a statement. Otherwise, it will some effect on hearing.
Yes, sir.
Last chance.
On the premise, please notice the matter for hearing up to 2 weeks.
Lordship.
He is permitted to file a joinder.
Lordship.
As a last opportunity.
Lordship. Lordship.
Much obliged, Lordship.
Much obliged, Lordship.